Hello everyone, and a very warm welcome to this HVG Law Webinar on Directors' Liability in 2025. My name is Ralph Mulder. I'm a Dutch corporate lawyer at HVG Law in Amsterdam, and today I'll be your humble host. So, I have the honor and pleasure to be flanked by two dear colleagues and subject matter specialists. On my right side, at least for me, for you on your left side, Lisa le Feber, who, like myself, is a member of our corporate transformations team in Amsterdam and knows all about directors' liability, directors' duties. And on my left side, Brent Crijns, who is a member of our digital, cyber and privacy team and the expert in cybersecurity and relating laws like DORA and NIS2. So what are we doing today? Well, in today's digital era, cybersecurity is no longer a mere IT concern. It has become, or at least it should be, a core boardroom matter. And with that shift comes increased legal accountability for directors and supervisory board members. With the introduction of the Digital Operational Resilience Act, in short DORA, and the NIS2 directive, European regulation is rapidly evolving to keep up with global digitalization. But at the same time, the framework provided by Book 2 of the Dutch Civil Code continues to be the foundation for assessing directors' duties and liabilities. And this is what we will be talking about today. Well, more specifically, looking at the agenda, we'll start with boardroom boundaries, basically directors' liability in a nutshell. And then we'll move to boardroom breaches. Why is cybersecurity a director's concern in 2025? And then we'll move to some statements that Brent and Lisa will comment on. And we'll close out with some closing reflections before we wrap up this webinar. So, proper introductions have been made. The agenda is public knowledge by now. So we will now proceed to set the corporate legal stage by discussing directors' liability in a nutshell. Lisa, the floor is yours.
Thanks, Ralph. Thanks for this introduction. So I will talk about the director's liability under Dutch corporate law. Under Dutch corporate law, directors can be held liable on two main grounds. We have the internal liability. Directors may be held liable by the legal entity for damages resulting from a seriously culpable mismanagement if they fail to fulfill their duties properly. And we have the external liability on the other side, and this involves liability towards third parties. So this is tort liability for unlawful acts, or in the event of bankruptcy, bankruptcy liability. Directors can be personally liable if their improper management is a significant cause of the bankruptcy. So now back to the internal liability and to the key aspects of the internal liability. So we're talking about a personal serious culpability. This means that if one or more directors engage in such improper management, all directors are jointly and several liable. So the whole board is liable for the act of one director. This is what we see as the key aspect, collective liability for all directors. However, exculpation is possible if a director can demonstrate the issue was outside of their responsibility and they were not careless in preventing damage. So outside of their responsibility could mean that the board has different tasks, which is usually stated in the Articles of Association. But that is not enough. There are two things that a director has to prove to succeed in this defense. So the first one is that the shortcoming was not attributable to them. And secondly, they took reasonable steps to prevent or mitigate the damage. So yeah, that's in short, in a nutshell, the key aspects of the internal liability, which is based on Article 9 of Book 2 of the Dutch Civil Code. Then we go to the key aspects of the external liability. So the external liability, as mentioned, covers tort liability. So directors are personally liable to third parties for unlawful acts, such as failing to meet obligations while knowing the company couldn't pay. And this means that a director is personally liable, not a complete board. So that's a difference from the internal liability. And this is an open norm, which is refined by case law. As just mentioned, if you're going to pay, selective payment could be which leads to like which leads to not paying other creditors and mismanagement of the company. Then we go to the bankruptcy liability. So directors are liable for shortfalls in the bankruptcy if mismanagement is a significant cause to the insolvency. And all directors are jointly liable if improper management is proven, so the complete board of the legal entity. The key aspects mean that this can only be initiated by the trustee. So the trustee is the only one who can enforce such liability on these grounds. And liability applies only if such mismanagement occurred within 3 years before the bankruptcy. So if something happened like 5 or 10 years before the bankruptcy, that is not taken into account on these grounds. And it needs to be improper management, which is very clear. And this is like not meeting administrative or publication obligations that the board has. And in this case, there is a double legal presumption of causality. So that shifts the proof to the directors. And the law gives us tools to the trustee to install bankruptcy liability on these grounds. And in such case, the directors have to prove that it was not due only to their mismanagement, but there were other grounds on which that caused the insolvency. So to conclude, directors under Dutch law face both internal and external liability for mismanagement. And as mentioned, this can be joint for the whole board or personal on a director's level solely.
Thank you so much, Lisa. I know you can, for a fact, you can talk about this for hours, but we do have a little bit of a time limit today. So thanks for wrapping this up in a very concise snapshot for our audience. Pivoting to Brent. Brent, may I ask you to shed your legal light on cybersecurity before we discuss or debate, maybe, I don't know, some statements?
Yeah, thanks, Ralph. So I think anno 2025, cybersecurity legislation is developing extremely rapidly. Its digital law as a subject matter is just extremely broad, and the EU is pushing more and more legislation. In 2025 specifically, we're looking at the NIS2 directive and DORA, Digital Operational Resilience Act. So NIS2 directive, which is a directive, so it has to be implemented, has been applicable for a while now, and it is not yet implemented in the Netherlands, but there is a draft Cybersecurity Act, which is expected to be implemented in the third quarter of 2025. And we have DORA, which has been applicable for a while. It's been applicable to their covered entities since 17 January 2025. So what are these laws? Basically, NIS2 directive is applicable to essential or important entities. So it's to entities that have a certain importance within our society and within supply chains. So let's say IT providers, cloud providers, we're talking about electricity undertakings, also transport, certain manufacturers. And we have DORA, which is more specific. It's also a lex specialis of NIS2, so it's a further implementation of NIS2, and it's applicable to the financial sector, so regulated financial entities, and their ICT service providers. Now, they both cover roughly the same topic, but NIS2 is more so specialized towards cybersecurity as a topic, so prevention of attacks from outside, guaranteeing that your data and your services are have a guaranteed confidentiality, integrity, and availability. DORA is more specialized, and it's digital operational resilience, which is, let's say, a more broad topic on how does my organization prevent any disruption on a digital front, and how do I recover, how do I learn and evolve from such disruptions. These two pieces of legislation, especially DORA, are quite extensive. So, for instance, DORA has, I think, roughly 1,200 new requirements for financial entities. Specifically for directors, however, they have a very sort of new role, which we're not used to in traditional legislation. So, talking about NIS2, NIS2 explicitly states that the management body of an essential or important entity must define, establish, implement, and oversee the implementation of cybersecurity measures, and also bears the ultimate responsibility for such implementation. So the entirety of cybersecurity risk management falls to the discretion of the board. Now, DORA is more specific. It actually has the same sort of basic provision, but it also specifies more clearly what the board actually has to do. So for instance, it states that appropriate governance must be foreseen. It has to implement reporting lines, so certain topics have to be reported directly to the board. There are also budgeting concerns, so you have to make appropriate budget available to manage cybersecurity risks. You have to ensure training and awareness among your employees. And critically, both of these pieces of legislation also state that the board itself must be trained. So NIS2 and especially the draft Implementation Act, the Cybersecurity Act, states the board has to have a certain training that meets the requirements of it, considering the cybersecurity risks for the organization, the measures that will be taken, and the way those measures implement or are implemented and affect those risks. This is once every 2 years. Let's say DORA has a bit more broad requirement for the management body. It specifically says you need appropriate training, and training appropriate to the risks that your organization faces. So not every financial entity has the same cybersecurity risks or the same resilience risks, but you need to be aware of those risks to understand what policy and what procedures are effective at managing those risks. Both of these pieces of legislation are inherently mostly public law. So they are subject to enforcement from supervisory authorities. For NIS2, this is the appropriate sector authority. For DORA, this is the competent authority for financial supervision. So that would be DNB or AFM in the Netherlands. Now, NIS2 has explicit measures towards directors. And one of those explicit measures is the suspension of directors from their function if the entity fails to implement appropriate measures. Another potential consequence could be fines of up to 10 million euros or 2% of the total worldwide annual revenue of the entity. And the draft Cybersecurity Act also has a specific fine of 25,000 euros to be incurred personally by a director if they fail to meet their training requirements. DORA, the fines are more so incorporated into existing financial supervision. For the Netherlands, this means that it has a fine of up to 5 million euros or 10 million euros for repeat offenders, which are to be incurred by the organization. I think those are the most important aspects that we're talking about today. Handing it back over to you, Ralph.
Thank you so much. Very helpful, Brent. So now that we have a clear insight and the high level of legal frameworks for directors' liability and cybersecurity, we can now bring them together by shortly discussing some statements on which, as I earlier said, Lisa and Brent will each have their chance to comment on. So the first one, NO 2025, directors can no longer hide behind a lack of technical expertise where it concerns the topic of cybersecurity and their responsibility. So who goes first?
Yeah, I'll take this one
Okay,
because
you're such a
it's
gentleman.
yeah, it is perfectly in line with what we just discussed, right? So there's no more reason for directors to say, well, I don't have the technical expertise. Because now as a director, you need the training. You are personally liable if you do not have the appropriate training. And you need to understand the risks that your organization faces. And you need to understand those measures that must be taken to manage those risks. So I think a lack of technical expertise is no longer any form of exculpation, at least from a public law perspective. But I don't know how that is corporate-wise.
Yeah, thanks, Brent. Yeah, I have to say, I agree with the statement, and that's because directors, they have a duty of care and they must act as a reasonable, prudent director. And this is also being informed about significant risks, including cybersecurity. And I think lack of technical expertise is no longer a valid defense. However, of course, the grounds for personal liability under corporate law are really high. But I think we are going to see that courts may assign like personal liability under Article 9 of Book 2 of the Dutch Civil Code or 162 of Book 6, the tort liability, that cyber risks and are increasingly maybe grounds or at least up for discussions in court cases. So we'll wait and see, but I'm expecting that the standard is evolving through the case law. Yeah.
Interesting, thank you both. We'll move on to the next one. NO 2025, NIS2 and DORA have effectively created a parallel track that exposes directors to personal liability more easily. So who takes it?
Yeah, I take this one.
Thank you.
And
Go ahead.
I don't agree, and that's
Okay.
because I don't think that NIS2 and DORA create a separate legal track for personal liability more easily. I think from a corporate law perspective, they might raise expectations for directors, especially in governance, and also the risk and compliance of a legal entity. But still, the corporate legal bar is high, and there has to be serious mismanagement. But yeah, it's an additional aspect that can be taken into account. So I'm certain that it doesn't make it more easily. It's just something extra that can be taken into account when being a director.
Yeah, definitely.
Yeah.
I disagree with this statement, and maybe not also more easily, but especially also the parallel track part, because it is not necessarily a parallel track if we look at public law. So there have been pieces of legislation in the past, such as the GDPR, also financial services legislation, that do allow for personal fines and personal liability for directors. But I think, crucially, these pieces of legislation provide a bit more enforcement power to competent authorities. So it's a bit more specific what can be done. But it's not necessarily a new parallel track. It's something that we've known for a while.
Very interesting. Thanks again. Last one. In 2025, companies are forced to change their culture, as having a cybersecurity policy on paper will no longer shield directors from liability.
Yeah, I'll take this one.
Go ahead.
So I think this is true. And this is, it's a bit of an open door, right? Because, of course, you cannot really suffice with just having a policy on paper. But I think more importantly, now we have very, very, very clear rules about not sufficing to have a policy on paper. So DORA especially is very explicit in that the board has to ensure the implementation of such policies and has to ensure that the financial entity learns and evolves from testing of those policies. So I think testing is very clearly a topic, and I think the same goes eventually for NIS2, where testing is of your policies and procedures is necessary, and ensuring implementation is is part of that testing.
Yeah, thanks, and I agree. I think in general, a written policy will never, prevent the directors or shield the director from liability. I think, yeah, like I mentioned in a previous statement that we had, that it's up to the courts to assess like the actual implementation and oversight of this new cybersecurity legislation to see what it really does to corporate liability based on the corporate laws. However, yeah, I think it could be seen that a failure to have cybersecurity in your governance of your organization, that it may be seen as serious mismanagement. However, we don't know that yet. We have to wait. But yeah, I agree to this statement. At least that a paper trail will never prevent you from the actual actions.
Yeah, definitely.
Thank you so much. Well, maybe the future case law will give a new reason to do a new webinar on this very interesting subject. So, yeah, we're slowly going to the end of the webinar. Some closing reflections from our side. I'll start. As we've seen today, the legal landscape around directors' liability is becoming increasingly intertwined with cybersecurity responsibilities. And this is a logical consequence, in my view, of an ever digitalizing world. The traditional foundation laid down in Book 2 of the Dutch Civil Code, think about concept of serious blameworthiness, the duty of care that Lisa talked about, remain firmly in place. But what is rapidly changing is the context in which these duties are exercised. So that's very interesting. And with the advent of NIS2 and DORA, directors are no longer able to simply delegate cybersecurity concerns solely to IT departments or a specialist team, or maybe even the chief technology officer for that matter. And these laws, as we learned from Brent, make clear that responsibility lies squarely with the board as a corporate body, and not only in terms of governance and oversight, but also in demonstrating adequate risk management system, incident preparedness, and continuous awareness. So yeah, what stands out from the legal analysis is this. Directors may be held personally liable not only under administrative enforcement frameworks, but also under civil law, Book 2, for example, and Book 6, 162, if they fail to act on known cybersecurity risk or neglect to implement robust internal control mechanisms. So the threshold remains very high. A serious reproach is still required, but in practice that bar may be met if systemic failures or ignored warnings come to light, and that we will hopefully, I would almost say hopefully, see in future case law. In short, cybersecurity is no longer just a technical matter, it's a boardroom matter, and it requires board-level engagement. Directors must embed cybersecurity into the DNA of their risk governance structure, ensure ongoing training, and remain alert to the evolving digital landscape. So my key takeaway, digital resilience is now part of a director's fiduciary duty, and with that shifts come not just the regulatory pressure, but also new standards of accountability, both collective and individual. So that's from my side. Brent, Lisa, maybe start with you. What's your key takeaway?
So my key takeaway is that in 2025, directors must drive a culture of compliance and not just the paperwork. They actually have to do things and be active and participate and be on top of all the trends, and definitely cybersecurity.
Yeah, thanks.
Oh yeah, I agree. So my key takeaway would be, I fully agree with both of you, right? Directors' liability is important, and this new legislation sketches a framework of directors' liability. But I also want the key takeaway to be that cybersecurity is an enabler for your organization. Cybersecurity and digital operational resilience ensures that your business processes remain active. So it's not just personal liability that is important, it's also preventing your company from going under in a ransomware attack. So I think that's my key takeaway.
Yeah, very good. Yeah. Some balance. Thanks, Brent. So, and with that, we are at the end of today's webinar. Thank you so much, Lisa le Feber and Brent Crijns, for your contributions today. It was an absolute pleasure to host this webinar and hear you talk about these subjects. You've given us a lot to think about regarding cybersecurity and in view of director's liability. And to everybody who's watching at home, thank you for taking the time to join us. We hope this session has provided you with valuable insights as well on how cybersecurity plays a role in the boardroom in 2025. And if you indeed liked it, please be sure to hit the like button or share the link or post it on your feed. That will be much appreciated by us. If you have any questions or follow-up comments, please do not hesitate, of course, to contact us via LinkedIn and DM or our email addresses, which are on the HVG Law website. And on behalf of our firm, HVG Law, thank you again for your attention, and we look forward to welcoming you to any future webinars. And we already put one down, right? When the case law is here, we'll definitely talk about it. Thank you so much. Have a great day.